Welcome back. And so we begin with legal matters, and the Supreme Court judgment on the powers of the president to declare an emergency rule is our first talking point this morning. And for good reason. How much of a precedent would it be in the coming days, especially in case we do not pray for it, similar events, in River State arise? And if that is the case, what will be the implications? So let's have a legal insight into that judgment this morning as Mr. Enibehe Effiong, legal practitioner, joins us. And we also have Mr. Chetam Nwala, a legal practitioner who also joins us. Both gentlemen will be joining us virtually on the program this morning. Mr. Nwala, we have you first, so thank you for coming on the program.
Good morning.
And as we begin, I've been taking time to look at the reasoning of the Supreme Court. And of course, it acknowledges that Nigeria is a constitutional democracy and the Constitution is our grundnorm. But it also says that regardless of the fact that all arms of government are independent and none is superior to the other, but in cases of extraordinary circumstances where the state may be imperiled, that the state government, the federal government, through the president, has the right to exercise its powers as dictated by Section 305. But the question is, and I wonder if you've taken time to also look at it, was the Supreme Court able to define what imperiled means within the context of what took place in River State, which necessitated the president to deploy the powers dictated by Section 305?
On the defense of the government, is always settled the national plans and how they take the time. What have done
you, Mr. Nwala, pardon me, we're having challenges hearing you. Perhaps you need to log out and click on the link again to join the meeting for the discussion, such that we can have a smooth conversation. That was very staccato rhythm as the conversation progressed. But it's a very important one, and we hope that we can have this conversation smooth sail when we have you back on the program. For me, guys, that first talking point was quite important when we have references, from past events. For instance, in 1962, I believe, when former Prime Minister also deployed his powers to invoke the state of the emergency in the Southwest region. One could, according to history, determine that indeed there was chaos, there was unrest in the Southwest region at the time. And, subsequently, Jeffrey, you were talking earlier on about, former President Olusegun Obasanjo and former President Goodluck Jonathan, in the exercise of the powers of Section 305, did effect a state of emergency, but we didn't quite see the suspension of democratic institutions, which is at the heart of the debate on this one. And so when the reasoning...
did. Suspended.
Suspended.
Yes.
So when we have the reasoning to the effect that, the state is imperiled, can we exactly say that that was the case in River State?
I think the debate here is what constitutes extraordinary measures. As I read the judgment, the Supreme Court really, in my view, stands to be corrected, just decided to explain context, leaving that discretion to the man in power, which is the president, the extent of threats, the functionality of democratic institutions, and like 3 premises they gave. So they just provided a bit of context to it. They did not say he can or he cannot. They just provided, that is my view, I stand to be corrected. Because the argument is, if you look at Section 1 of the Constitution, section 1, section 2, if you look at section, I think 411, other sections, there are like 5 ways you can remove a governor of a state, at least a governor of a state, for instance. First, his tenure has to expire. Second, maybe he resigns. Third is impeached. Fourth, a court removes him, maybe all this tribunal and all of that. And then fifth, he dies. Those are the 5 premises that the Constitution contemplated and provided for by law. And so some people like us who believe that outside that premise, you will resort to self-help if you remove elect. Because what we are dealing with here is not just a president removing a governor or suspending a governor or a national state assembly. It's about tampering with the sovereignty that belongs to the people. So you can see the Supreme Court also was very strong in saying they are equal. That's why it's called a federation. They are equal, but of course, when it comes to responsibility and all of that, certain things are bigger at certain levels. But I think we understand that Mr. Bukola Chetam may be back.
Because if that then is the strength of is the heart of the matter as far as the debate is concerned, then we may have to concede that, you know, the interpretation of the Supreme Court, which is saying that the Section 305 is not specific on the nature of the extraordinary measures, then are we going to now concede that, you know, that will be the precedent henceforth, regardless of what the Constitution says about, you know, the procedure that should be taken to suspend a president? I believe we have Mr. Chetamwala back. Mr. Mwala, have you been following the conversation? Which is it for you? The determination of what imperiled circumstances is as defined by the Supreme Court, or more importantly, the extraordinary powers that the president can wield?
Well, I think both is actually important, because it is important that there is checks on the both the powers of the president, and we should as well know what extraordinary circumstances mean. And these are some of the things some of us had expected the court to define and to clearly give perspective to, because it seems like the Supreme Court also assisted us to also further put us in the dark with respect to these issues. Because when you read the summary of the judgments, although we are yet to get the full judgment, as it were, when you read the summary of the judgment and you look at the reasoning of the Supreme Court with respect to the matter at hand, you will definitely agree with me that the core and critical issues were not decided on. They were still left hanging by the Supreme Court. And these particular issues have continued to linger. That as of today, we do not have a clear-cut a clear-cut definition of what these extraordinary measures are, of what constitutes extraordinary situations. So we will still continue to have this, go through the same wranglings every day. And the Supreme Court is supposed to help us interpret the Constitution and to make us understand what the position is. Even if some of us are not too comfortable with the line of reasoning of the Constitution, but of the Supreme Court, but I must state categorically that what the Supreme Court did yesterday was to strike out the matter on the grounds of jurisdiction, and went ahead, as is allowed in the practice directives, and went ahead to comment on the issues at hand. Now, commenting on the issues at hand does not make the issues being commented on binding, but it will remain persuasive. It will remain persuasive in subsequent matters. Now, because the Supreme Court had already originally declined jurisdiction on the matter, even if some of us feel that the Supreme Court declining jurisdiction on this particular matter doesn't really serve the best interest of Nigeria, or doesn't serve justice as it's supposed to be. Now, but we must also be careful when we are dealing with this issue that the Supreme Court has made a suggestion via the comments it made on the substantial issue, which it actually went ahead to affirm that the president can decide to either suspend the governor or to leave the governor, like the example he gave with both the Jonathan administration and the Obasanjo's administration. This is really sad for our democracy. I must state clearly that this is sad for our democracy, because we have expected that the Supreme Court will step in and salvage our democracy on this particular issue of national importance, and not to further create confusion in the circumstance. Let me say this. However persuasive the comments made by the Supreme Court on the substantial issue is, it will not form the opinion of future direction of these politicians. Let me tell you, politicians take advantage of every situation they find themselves. They take advantage of the circumstances the situation with respect to this unclarity within the purviews of our laws. They take advantage within with these loopholes being created by the Constitution, by the Supreme Court, as it were. Now, we must also be careful to make sure that we do not have a president who relies on the opinion, emphasis on the opinion of the Supreme Court that is not binding, looking at the fact that the matter was struck out. Because we must keep emphasizing on that. That is not binding, and now act on it and say this is the law, as stated by the Supreme Court in the case of Adamawa State government against the Federal Republic of Nigeria. We must be careful in dealing with this particular issue. So that is why we had expected that the Supreme Court would give clarity to this issue. But trust me, from the look of things, there were no clear-cut distinction on some of the critical issues that had led to several debates on television and everywhere around the country for the past 1 year on this particular issue. The Supreme Court did not really do justice to it, to defining them clearly. But however, from this summary that was given, but we'll still wait to see what will come out from the judgment itself, but we'll get to read the new judgment itself. Right. There will be something different from what we have seen with the summary that was issued out yesterday.
So to help Nigerians understand, because a few times when judgments like this come, it'd be a bit too cumbersome for people to really process. So to be clear, the Supreme Court said, well, we don't have jurisdiction over this matter, but we can speak on some of the issues in that sense, right?
Yes.
Okay, good. So people can understand what the outcome of the judgment is. But before I get to the dissenting judgment from Justice Obande Ogbunya, which is forming a major talking point now, perhaps we should also speak to the context of this particular case. So originally, we had Adamawa State and 10 other PDP-led states going to court to challenge the emergency rule and the suspension of their colleague from Rivers State. So in that case, we had Adamawa, Bauchi, Zamfara, Plateau, Bayelsa, Enugu, Oshu, Akwa Ibom, Delta, Taraba, and Oyo filing that case. Of course, Rivers State was not involved. But few months down the line, the 11 has become 5. So 6, in fact, this case that is quoting PDP, 11 PDP-led states should actually be 5 PDP-led states right now. So saying that's the circumstance, the same people who were saying the president should not have done this have now moved to the side of the president, essentially saying thumbs up to you. Do you think that that is some sort of irony? And I know it doesn't concern the case, but it's disturbing to see this. Does that concern you?
I must say that personally I've been very concerned about it, and I must also mention that the delayed pronouncement of the Supreme Court also contributed to this, because at some point it looked like everywhere we have all been captured by the renewed hope mandates of Mr. President, his 2027 ambition. You remember, I have always stated, and I will keep mentioning, that the declaration of state of emergency in Rivers State was purely political. It was not about stabilizing Rivers State at all. It was the president trying to make sure that his presidential ambition for 2027 is being protected within the purview of Rivers State. And of course, we have seen what has happened to the governor of Rivers State, where the governor of the state has been hoodwinked, and we have seen a governor who came back, returned like a wounded and a defeated lion. Having returned back, he has now moved down to the opposition to work with the opposition, and now he's saying that he's now a member of the APC. Now, this was all because there was a state of emergency. This was all because the president had a 2027 ambition, so he didn't care whether the Rivers State economy was dying, whether anything was happening to Rivers State. His interest was to make sure that the governor comes to his knees, which they succeeded, and he also moved to the APC. Now, the Supreme Court, who was supposed to intervene in all of this, kept quiet for too long. And this is what we keep saying, that matters of national importance like this should not be allowed to linger for this long, like we have seen. The Supreme Court was supposed to weigh in and deal with it decisively. Whether they had jurisdiction or not, we should have heard about these things. Now it has become an issue of academic exercise, and the Supreme Court is striking out the matters up today. So This caused for serious worries. The governors themselves became unsafe. Do not forget, you recall when the governor was, when the president was recalling back the governor of Rivers State, in his statement, he clearly stated that where governors do not work in the House of Assembly, that he can come in to declare state of emergency. He actually created that particular impression in that particular statement. And this naturally created fears in the minds of the governors. Of course, we have weak governors today across the country. We have the kind of governors who see they are puppets to one political godfather or the other. That's what we see today as governors. Across the country, in almost every state you have today in the country, we see the governors being loyal to one person or the other. So naturally, when this person have an alignment with the president, they naturally move with their political godfathers to whatever party the president belongs to. And this is the sad situation for our democracy, because what we have gradually turned in this country into a one-party state, where the president will sit at the comfort of his home, decide what happens in the country, and nobody says anything. The National Assembly already on its own is completely defeated. The judiciary is actually playing a hanky-panky game with the executive, and this calls for serious concern. It calls for serious concern as a people, because we are gradually losing our democracy. Our democracy, as it is today, it's at the point where all Nigerians should be sober and should be worried about it, because a lot has gone wrong in this particular nation. The fact that governors are leaving from the opposition party to the ruling APC does not signify that the president is doing well. It only signifies that the president is trying to hoodwink everybody into making the country a one-party state. Yes. And because they're supposed to intervene, it's not doing their job and they're supposed to do it.
If I may come in, Mr. Chetam, politicians will always be politicians. The concern that has now progressed to worry for me is what the laws and the lawyers and the judges are saying. So I want you to respond to maybe two questions as in quick succession, if you can, as far as this issue is concerned. When Joshua Dari, a former governor, went to court, one of the reasons why his case was struck out or dismissed or so was to the effect that he also did not have a local standard because he was suspended. Now, this case has also gone to court. They said, look, the states that brought this case to court, there is no altercation or disagreement between you and the federation or federal government. So why exactly are you here? That's just using a layman's term. So it looks like ab initio, except the person that is, we've had a person that was affected go to court. Court said, perhaps you're suspended, so you cannot institute the suit. Now, other people have gone to court saying it wasn't you that was affected. I don't know what the Supreme Court wants on how this suit can be instituted. But that's on one hand, if you can comment on that. But the other hand is the procedure. There's something the Supreme Court said that I want you to look at. And that in itself, whether it invalidated the president's decision, because as far as I'm concerned, that judgment did not say it can or it cannot. It just gave a context and comparison. Page 12 of that judgment says, significantly order 11 Rule 6 empowers the Speaker, this House of Reps now, where a matter is of national concern, to order a division with votes recorded by name, constituency, and choice, and published accordingly. A proclamation of a state of emergency is unquestionably a matter of national concern, and the standing orders accordingly provide a mechanism for transparent and verifiable determination of a required supermajority. I remember this was a big issue. So if you look at how the Supreme Court read out the standing order, would you say that the House of Reps, for instance, I know these academic experts actually followed their own standing rule in endorsing the decision of the Supreme Court?
First of all, I must say that in answering this, it was actually clear that the Supreme Court actually faulted the House of Reps voting pattern with respect to this particular issue, using voice votes in the circumstance. And the Supreme Court was clear about it. So it simply means that the entire process, on one hand, is flawed. The entire process is flawed by virtue of the fact that the House of Reps did not follow the appropriate guideline by its own standing order in giving. In passing out the said, in carrying out the said vote at the floor of the House of Reps. So it naturally makes everything the president has done to be completely and clearly wrong. But you see, these are the issues we have also, that's why we keep criticizing this judgment, that the Supreme Court did not also come clear to state that what they did is right or wrong, and that's what Nigerians expect. That's what Nigerians expect. Now, this interpretation will now create for further interpretation for and against. And this has continued to bedevil our legal system. And that's why you keep having contrary interpretations, because the Supreme Court on most occasions have chosen not to be clear with its own decision. Now, to your first question, if you can just remind me again, that's your first question, please.
Yeah, because I was just talking about who can then institute a suit when the Supreme Court told you. Yes.
Now,
if you can do it in 1 minute, 1 minute.
Let me say this. It also further brings, all the matters that have been filed, including the local government election issues we filed at the court. The court still hint on this issue of jurisdiction to knock off this particular matter. And we keep asking, who then? You said the governor has been suspended, so he cannot come in the capacity of the governor of Rivers State to file this particular matter. These PDP governors have interest because they are governors. And if this thing is happening to this person that is unlawful, there's every likelihood that it will still happen to them. So therefore, trying to forestall the same situation, unlawfulness or ultra-vires action of the president to come upon them. And you're saying that they do not have the locus to bring the matter before them, that they needed to seek the permission of the Rivers State government. Is it the sole administration that will give the permission? The Supreme Court has further made things difficult by taking this particular position. The particular position was not meant to bring justice at all. Yeah. This position has only made things more difficult for Nigerians and for future litigation. Because it simply means that when these actions are taken, it should not be challenged.
Indeed. I'm just wondering if, the person in question, the victim here, didn't have the right or the guts, as the case may be, to institute the case, under the circumstances. But let's expand the conversation as Mr. Enibehe Effiong, another legal practitioner, now joins us in our Lagos studio. Mr. Nwala has spoken quite passionately about this matter. We've moved from whether the Supreme Court was able to define imperiled circumstances that warranted the exercise of powers from Section 305, or whether Section 305 was vague indeed about latitude of the president to deploy his powers. I'd like you to speak to that as well. But more importantly, we do say that the wheels of justice grind slowly. But this is coming a whopping 9 months after the declaration of a state of emergency. Can we say that justice in this case has been neutral, neutralized, or aborted?
Thank you. Let me just quickly say that I have read the summary of the judgment of the Supreme Court, which I have with me here, created and delivered by the Honorable Justice Mohammed Baba Idris. My impression of this judgment is that, one, the Supreme Court did not endorse the state of emergency in Rivers State. The Supreme Court did not say that the president acted in compliance with the Constitution. What the Supreme Court seems to have said, from what the printed summary that is available, is that the Constitution, Section 305, allows the president, in making a proclamation of a state of emergency, to take extraordinary measures to restore order and so on. And that the phrase extraordinary measures is not defined. But the court went further to say that even in doing so, the National Assembly has to pass a resolution supported by not less than 2/3 majority approving that state of emergency. And then they also stated the manner in which that vote to determine the 2/3 is to be done, is to be cast. And they concluded regarding the House of Reps, for example, that it has to be by a division. Members have to be counted by their constituencies and names. So on the basis of that alone, looking at what transpired in Rivers, one can safely conclude that the state of emergency in Rivers State was illegal and unconstitutional, having not been endorsed by the National Assembly in compliance with the process set by the Supreme Court. Now, there's an argument as to whether the Supreme Court envisaged the possibility of democratic structures being set aside temporarily, being suspended. There is an aspect of the judgment where the Supreme Court cited the Constitution of Pakistan and India to say that in those countries, the Constitution allows, during emergency, proclamation for institutions at the subnational level of government or the parts of the country affected to be taken over by the federal government. But the court went further to say that in Nigeria, there is no such power given to the president. So the way I see this is because having declined jurisdiction, having held that the states, the 11 states, Adamawa and others that brought this suit did not have reasonable cause of action. The state of emergencies was not declared in any of those states. They did not show that they had the authority to represent Rivers State. The Supreme Court did not want to go into the merit of the matter. They only commented briefly. They only gave a brief opinion on what the Supreme Court has opined to be the constitutional framework regarding state of emergency. But nobody should go with the belief that on the basis of this judgment, the Supreme Court has now approved or has now given legal teeth of validity to what President Bola Ahmed Tinubu and the National Assembly did. Because even in the judgment itself, the Supreme Court affirmed that Nigeria is a federation, operates a federal system of government, and regulated by Section 4 to 7 of the Constitution, and that no arm or tier of government is superior to the other. And when you look at what the late Professor Ben Nwabueze called doctrine of mutual non-interference, implied prohibition, or intergovernmental immunities, in his book Democracy in the Emergent States, you cannot have a situation in a federal system where the head of a subnational government can just be removed at will by the head of the national government. So I believe that we have to be very cautious in our assessment of the decision of the Supreme Court. As it is now, I believe there is need for a constitutional amendment to clearly set out the extent and the ramifications of the emergency powers of the president. Because if you, for example, if the position is that on the basis of extraordinary measures, the governor can be suspended temporarily, the House of Assembly can be suspended, how about the judiciary? For example, can we also say that in the case of a state of emergency in a state, the president can, for example, we have some states now, I can tell you, we have some states in the country that the judiciary is struggling to function because, for example, the governor has refused to allow the person that is supposed to be the chief judge to function. Can the president in that instance declare some sort of emergency and dissolve the judiciary, or now appoint unilaterally persons to be heads of the judicial arm of government? So there is need for a constitutional amendment to clearly delineate the constitutional ramifications of the emergency powers of the president.
Very valid points here. But ironically, the person you would have said would have had jurisdiction to take this case to court is now in the APC. In fact, 6 out of the 11 states that originally went to court or said they went to court are also in the APC.
Yes.
Right. So what exactly is at play here? Because for a lot of people, they've looked at the judiciary and they've always thought, there's more at play here, right? You expect that the judiciary is independent on paper, but when you read the judgments, you go through the proceedings, what looks like common sense now looks very complicated in court. But we must reference Justice Obande Ogbonia, who first said, well, I think that this case in part succeeds in that sense. And also, I said the president cannot use such powers that he has under the Section 305 to declare state of emergency to suspend elected state officials. So it looks like this is the bite, although it's a minority bite in the judgment. Well,
a minority judgment, quite regrettably, is not the decision of the court. The decision of the court is to be determined by the opinion of the majority of its members. This constitution is clear on that. On this matter of local standard, I think it's a bit tricky for me, because looking at what the Supreme Court also said in the case of Plateau State of Nigeria and Attorney General of the Federation, there was no way Rivers State was going to bring this action, because Fubara had been removed. No, Rivers State couldn't have brought this action. Fubara had been removed. And by what the Supreme Court said in the case of Plateau State of Nigeria and AG Federation, there was no way the sole administrator was going to authorize that action, because you needed his authorization. He was, in some sense, the de facto head of the government of Rivers State. There was no attorney general who could have brought this action. So I believe that one way or the other, this matter will still go to the Supreme Court later in the future. I do not think that this is the end of the matter, because don't forget, based on, as I said, based on the summary that we have seen that has been released, printed and released, there is nowhere explicitly in the 14 pages that I have here where the Honorable Justice Idris, who read the summary, said that the state of emergency in Rivers State is constitutional. Nowhere. All that my lords said was that the extraordinary measure is not defined, and in some sense, my lord cited the case of under the former President Obasanjo in Plateau State and Ekiti, where democratic structures were removed. The case of Jonathan, I think in 2013, in Adamawa, I think as one other state, where it was not removed, and said that, look, there seems to be some latitude, depending on the peculiarities, but nowhere was this specific state of emergency, from what we have already, affirmed to be lawful and constitutional.
It's important we brought that clarity, but almost thank you. We wish we had more time. So we just felt that this time we would have gotten a finality. I read and looked whether I'm missing something. I had to look. I said, I can't see anything here that I can go home with. As just take it as it is. It can be this way, it can be that way.
Thank you.
Legal practitioner, Chetan Wala as well, who is a legal practitioner. Both gentlemen joining us, both in studio right here and virtually. Thank you for coming on the program. I appreciate you.
Thank you.